This is the brief on the Philippines Terrorism Financing Prevention and Suppression Act of 2012. This law chokes off the financial lifeblood of terrorist networks, making funding a severe standalone crime and giving the government aggressive tools to track and freeze dirty money. First, providing or collecting terror funds is a massive crime punishable by life in prison, reclusion perpetua, and million-peso fines. You might be wondering, what if the terror attack never actually happens? It's like getting arrested for arson just for buying the matches. Under this law, the crime is fully committed the second the funds are provided, even if that money is never actually used in an attack. Now that we know what the crime is, how does the government actually catch the money before it moves? Second, sweeping powers go to the Anti-Money Laundering Council. They can investigate deposits, completely bypassing normal bank secrecy laws. Wait, no court order at all to look at your bank accounts? That's right. Treating this as a supreme threat, they can instantly freeze assets for 20 days, extendable to 6 months. So the government has an iron grip on the money locally. But what if a funder tries to set up shop outside the country? Finally, leaving offers no protection. Think of this law as having a very long, invisible leash. It covers Filipinos worldwide and foreigners abroad funding crimes against the Philippine government, citizens, ships, or aircraft. You can't just cross a border, wire some cash, and claim you're out of their jurisdiction. Ultimately, this law guarantees that the people quietly writing the checks for terror face the exact same devastating consequences as the people carrying out the attacks.
You know, every major terrorist operation has one thing in common. It needs money. Without cash, the entire machine just grinds to a halt. So, how do you fight it? Well, one of the most effective ways is to go after the money. In this explainer, we're going to break down the Philippines' key weapon in this fight, the Terrorism Financing Prevention and Suppression Act of 2012. Let's see how it cuts that lifeline.
So, here's our game plan. First up, we'll dig into the fundamental why behind this law. Then, we'll nail down exactly what terrorism financing is. After that, we'll look at the pretty serious consequences for anyone involved, check out the powerful tools investigators have, and finally, we'll see how this law's reach extends way beyond the country's borders.
All right, Section 1, a stand against terror. So before we get into all the legal nitty-gritty, we really have to understand the core reason this law was created in the first place. What's the mission statement here?
Well, the law itself doesn't pull any punches. It flat out declares that funding terrorism is inimical and dangerous. Now, that's not just fancy legal talk. It's a powerful statement that says giving money to terrorists is a direct threat to the safety and well-being of every single citizen. And what this really does is frame the act of financing terrorism not just as a regular crime, but as a crime against the Filipino people and really against humanity itself. The whole point is to protect the most basic things we value, life, liberty, and property, by cutting off the financial oxygen these groups breathe.
Moving on to Section 2, what is terrorism financing? Okay, so we've got the why locked down. Now let's get into the real meat of it, the what. What specific actions actually count as a crime under this law? Here it is, the core definition straight from the Act, but let's put it in simple terms. It boils down to this. If you handle assets of any kind, and you either intend for them to fund terrorism or you simply know that's what they're for, then you've committed the crime. Think of it like this. There are a few key ingredients. First, you have the act itself, handling the money or property. But the crucial part, the thing that makes it a crime, is what's in your head. It's either your direct intent for that money to be used for terror or your knowledge of its purpose. And get this, you don't need both. Just one is enough. Now, this next part is a real game changer. The money doesn't actually have to be spent on a bomb or an attack for the crime to be committed. The crime is complete the second the financing happens. The act of writing the check, so to speak, is the crime. This makes it so much easier to stop attacks before they even start.
So you might be wondering, what exactly counts as funds? Well, the law is written to be incredibly broad, and that's on purpose. We're talking about everything: cash, real estate, stocks, bank accounts, and yes, even cryptocurrencies and other digital assets. They wanted to close every possible loophole.
Okay, Section 3, the cost of complicity. We know what the crime is. The big question now is, what happens if you get caught? As you'll see, this law doesn't just go after the person writing the checks, it targets anyone who helps out.
The law basically sees it as a team effort, right? So it breaks down the roles. You've got the principal, that's the main person doing the financing. Then there's the accomplice, who helps them get it done, and finally, the accessory, who might help clean up the mess afterward. And trust me, all of them face serious heat. And when we talk penalties, we are talking about some of the most severe ones. For the main offender, it can go all the way up to reclusión perpetua. In the Philippine legal system, that is, for all intents and purposes, life imprisonment. It just goes to show how seriously this crime is taken.
And it's not just about losing your freedom. They hit you where it hurts, your wallet. The fines are hefty, ranging from $500,000 all the way up to 1,000,000 pesos. It's a double whammy of prison time and financial ruin. The law actually goes even further. It creates a whole separate crime for just dealing with assets you know belong to a designated person or group. Think of these as individuals or organizations on an official blacklist flagged by the government or the UN. If you knowingly touch their money, you're breaking the law. Period.
All right, Section 4, the power to investigate. You know, tough laws are great, but they're pretty useless without teeth. So how do authorities actually catch people doing this? Let's look at the tools they have in their arsenal.
The main character in this story is the Anti-Money Laundering Council, or AMLC for short. They are the lead agency, the ones with the authority to go in and investigate any funds or property they suspect are tied to terrorism.
And these guys wield some serious power. They can investigate assets, they can issue orders to freeze those assets immediately, and now this is the big one, they can examine bank accounts and investments without a court order. That lets them bypass the usual bank secrecy rules, which is huge in these cases.
So imagine this, the AMLC suspects something's up. Boom, they can issue a freeze order, and it happens instantly, locking everything down for 20 days. That gives them a window to dig deeper, and they can ask the Court of Appeals to extend that freeze if they need more time.
But here's where the law tries to strike a balance. It's not a complete free-for-all. They've built in what are called humanitarian exceptions. So, if your assets are frozen, you can actually go to court and ask to withdraw money for essential things, like food for your family, medical bills, or to pay your lawyer. It's powerful, but it has guardrails.
Now for our final section, beyond Philippine borders. We all know that terrorism is a global problem, with money flowing across continents like it's nothing. So, does this law just stop at the border? The answer is a hard no. This is where we get into something called extraterritorial reach. It's just a fancy way of saying this law has really long arms. So, if you're outside the Philippines but the crime you commit happens inside the country, the law can get you. If you commit the crime on a Philippine ship or airplane, it can get you. If your crime is against Filipinos, it can get you. And most importantly, if you are a Filipino citizen, it doesn't matter where on earth you are, this law applies.
So the takeaway here is crystal clear. There's really no safe place to hide. Geography is not a shield. If you're involved in funding terror and it has a connection to the Philippines, this law is designed to find you.
So, let's bring it all together. What we've seen is that this act is a really comprehensive legal framework. It clearly defines the crime. It sets out incredibly harsh punishments, and it gives investigators the far-reaching power they need to hunt down and prosecute those who provide the financial lifeblood for terror.
But all of this power brings up a really big fundamental question, doesn't it? When you give a government such extraordinary tools to keep its people safe, you're walking a very fine line. It leaves us with this challenge to think about. How does a society strike that perfect balance between security and liberty? How do you protect people without infringing on the very freedoms you're fighting for?
Imagine you wake up on just a perfectly normal Tuesday.
Right, just a regular morning.
Yeah. You head down to your local cafe, you order your usual, and you tap your debit card on the reader. And it declines.
Which is, a minor annoyance. Happens to everyone.
Exactly. So you pull out your phone, you open your banking app to see what's going on, and you find that you are completely locked out.
Oh, wow.
Yeah, not a glitch, not a maintenance message. I mean, your accounts are just zeroed or frozen.
That's terrifying.
It is. And you haven't been arrested. No police officer has knocked on your door. You haven't been charged with a single crime in a court of law, right?
Not a single one.
But because an algorithm running deep inside some banking server noticed that you sent a few $100s to a cousin who, operates a small business in a recognized conflict zone.
Just a normal wire transfer?
Right. Because of that, a secret government council has effectively erased your financial existence overnight.
It's the modern equivalent of being exiled. But you never even leave your living room. Your ability to participate in society is just switched off.
Switched off completely. Welcome to this deep dive. If you're joining us today, you are someone who wants to understand how the world actually works behind the curtain.
You're looking for that hidden architecture.
Yeah, we spend so much time thinking about national security in terms of, kinetic warfare, soldiers, drones, physical barricades.
The physical stuff.
Right. But the reality is the most aggressive front lines today aren't physical trenches. They're routing numbers.
Compliance forms.
Yes. Compliance forms, the terms of service on your digital wallet. Today, our mission is to dissect exactly how a government weaponizes its own legal and financial systems to just choke off the oxygen to global threats.
We aren't looking at the battlefield today. We're looking at the bank account.
Beautifully put. And to really understand the mechanics of this invisible warfare, we are analyzing what is basically a masterclass of a document.
It really is a foundational text. It reveals the precise anatomy of how modern states track, freeze, and destroy the flow of capital.
We are looking at a specific, pivotal piece of legislation from the Philippines. It's called Republic Act number 1668.
Also widely known as the Terrorism, Financing, Prevention, and Suppression Act of 2012.
Right. Now, you might be wondering, why look at a domestic law from the Philippines to understand a global concept?
It's a fair question.
Yeah, but it's because this document is the perfect microcosm. I mean, it is the perfect blueprint. We're going to explore how this law fundamentally redefines the concept of money.
And we're going to look at the staggering powers granted to investigators to completely bulldoze traditional financial privacy.
Oh, we are definitely getting into that. And we'll see how a single piece of domestic legislation can stretch its jurisdiction across the entire globe.
It's a massive reach.
Okay, let's unpack this. Before we get into the secret bank inquiries and, the life sentences, we have to look at the philosophy driving this text.
Right, because a law this aggressive doesn't just materialize out of nowhere.
No, it doesn't. There is a massive foundational tension right at the beginning of the text in the Declaration of Policy.
That's right. When you read the opening principles of this act, you see the state attempting to balance two forces that are essentially, they're at war with each other.
How so?
Well, the state explicitly declares that its policy is to protect life, liberty, and property from acts of terrorism. It condemns the financing of these acts in the strongest possible terms.
That makes sense.
But in the exact same breath, it mandates that the state must prevent and suppress these offenses, quote, while protecting human rights.
I have to admit, when I read that, it felt like a total contradiction.
Oh, it definitely reads like one.
It feels like legal doublespeak, right?
Yeah.
I mean, how on earth do you aggressively seize someone's life savings, freeze their ability to feed their family, and completely bypass their right to a fair trial before taking their property?
All that warning.
Right. While simultaneously fulfilling an explicit mandate to protect human rights? It doesn't track.
It is the defining paradox of modern democratic security, honestly. The drafters of the law are fully aware of the contradiction.
They have to be.
Yeah. If you wait for the full, slow process of a transparent public trial with total due process...
The money moves.
Exactly. The money moves, the bomb goes off, and human rights are violated by the terrorists.
Right.
But if you move instantly to freeze the assets without warning, you risk violating the human rights of an innocent citizen who is just, falsely flagged.
Which happens.
It does. The state is essentially calculating that the human rights violation of a successful terrorist attack is so catastrophic that it justifies a severe, albeit temporary, suspension of financial liberties to prevent it.
But the text goes even further to justify this. It doesn't just say terrorism financing is a crime against the state.
No, it elevates it.
Yeah, it explicitly labels it as a crime against humanity and against the law of nations.
Against the law of nations. That is not a phrase lawyers throw around lightly.
What does it actually mean in this context?
Historically, crimes against the law of nations, or just gendium, were reserved for things like piracy on the high seas or the slave trade. These were crimes deemed so universally abhorrent that the concept of national jurisdiction just didn't matter.
So anybody could go after them?
Exactly. Any nation, anywhere, had the moral and legal authority to capture and prosecute a pirate, regardless of the pirate's nationality or where the crime occurred.
Okay, so by elevating terrorism financing to this exact same tier, the law is making this profound philosophical statement.
Yes. The person sitting in an air-conditioned office in a financial district holding the checkbook is legally and morally indistinguishable from the person holding the weapon.
Because the financing is the engine.
Exactly. It is the potential energy of the violence. But I want to address something crucial about why this law exists in the Philippines in this specific format.
Yeah, laid out.
It did not happen in a vacuum. It was forged in the fires of international pressure. The text explicitly references the United Nations Security Council,
Right.
specifically Chapter 7 of the UN Charter.
Okay, let's translate that for our listeners, because Chapter 7 sounds like, I don't know, boring bureaucratic numbering.
It does.
But it is actually the heaviest hammer the United Nations possesses, right?
It absolutely is. I mean, the UN Charter is effectively the constitution of the international system. Most of what the UN does is issue recommendations.
Like, we strongly advise member states to do X.
Right. But Chapter 7 deals with threats to global peace and acts of aggression.
So it's not a suggestion.
Definitely not. When the UN Security Council issues a resolution under Chapter 7, it is a binding global mandate.
Wow.
It is the legal mechanism that allows the UN to authorize economic sanctions, blockades, or even, international military force.
So when the UN Security Council issues a Chapter 7 resolution saying every nation on Earth must instantly choke off the funding of these specific terrorist organizations,
A member state like the Philippines doesn't have a choice.
they have to comply.
They have to comply.
Yeah.
Or they face the wrath of the international community, which could mean being blacklisted by the global financial system.
Which would destroy their economy.
Completely. But here is the logistical problem. The UN Security Council does not have a global police force.
Right, they can't just send UN troops to audit a bank.
Exactly. They don't have the password to a bank manager's computer in Manila or London or New York. The UN can declare the mandate, but it relies entirely on individual member states to build the local machinery to enforce it.
That makes perfect sense. So Republic Act 10168 is essentially a local gear inside a massive interconnected international machine.
Precisely.
The UN provides the blueprint, but the domestic government has to cast the iron and build the trap.
And if you are building a trap designed to catch the funding of terrorism, you have to be incredibly specific about what you are trying to catch. You have to define the tools of the trade.
Which brings us to the definitions in the text, and I want to push back on something here if you don't mind.
Go for it.
When we talk about cutting off the oxygen, it sounds very neat and tidy, but terrorism today isn't always a multi-million-dollar operation.
Trigger.
We've seen horrific, devastating lone wolf attacks carried out with like a rented truck and a kitchen knife.
Yeah.
Those cost almost nothing, $50. Is a sprawling, multi-agency financial dragnet actually effective against modern, cheap, decentralized terrorism? Or is this law fighting the last war?
That is the exact right question to ask, and it strikes at the heart of the law's complexity. You are right that an individual tactical attack can be incredibly cheap,
Right.
but maintaining an organization is expensive. Recruiting, training, producing propaganda, maintaining encrypted communication servers.
Bribing border guards, housing operatives.
Exactly. All of that requires a constant, heavy flow of capital. The law isn't necessarily designed to cash the $50 used to rent the truck. It's designed to starve the apparatus that radicalized the driver and provided the logistical support.
Okay, so to do that, the net has to be cast impossibly wide.
And it is. Let's look at exactly how wide that net is. Section 3 of this act is the definition of terms, and the definition of property or funds is staggering.
Staggering is the word.
Yeah. It covers, quoting the text here, financial assets, property of every kind, whether tangible or intangible, movable or immovable, however acquired.
The key word there is intangible, right?
Absolutely.
Because it goes on to list bank credits, travelers' checks, shares, securities, bonds, drafts, letters of credit. But intangible takes this to a whole new level.
It really is.
We aren't just talking about suitcases of cash or gold bars hidden in a basement. We are talking about intellectual property, patents, copyrights, digital tokens, complex financial derivatives.
Think about the foresight in that drafting. This law was written in 2012.
Right. Bitcoin was just a baby.
Exactly. Bitcoin was in its absolute infancy. The phrase decentralized finance barely existed.
Yeah.
But by including electronic or digital instruments and an intangible property, they future-proofed the legislation.
That's wild.
If a terrorist organization tries to fund itself by minting an NFT or by holding the rights to a piece of software that generates licensing revenue, this law immediately captures it.
It's like trying to outlaw not just the fire, but the concept of friction itself. You cannot possess anything of value without it falling under this definition.
It's a great way to put it.
But that is only half of the equation. That defines the money. How does a purely financial law define a terrorist act?
What's fascinating here is how the drafters solved a massive legislative headache.
What was the headache?
Well, normally, if you write a law against terrorism, you try to list the bad acts. Hijacking a plane, bombing a building, assassinating an official.
Sure, you make a list.
But tactics constantly evolve. If you make a list, terrorists will just invent a tactic that isn't on your list.
And technically, funding it wouldn't be a crime under this specific law.
Exactly.
So how did they get around that?
By tethering the domestic law directly to international treaties. Section 3J of the Act lists 9 highly specific international conventions that the Philippines is a party to.
Let me look at this list because the scope is wild. It includes the 1970 Hague Convention on the Unlawful Seizure of Aircraft, the 1980 Vienna Convention on the Physical Protection of Nuclear Material, the 1988 Rome Convention for the Suppression of Unlawful Acts Against the Safety of Maritime Navigation.
It's extremely specific.
It even includes a protocol about fixed platforms located on the continental shelf.
It is brilliant legislative architecture, really. Instead of trying to predict every conceivable way a terrorist might attack a country, they simply plugged their financial law into these massive, pre-existing global agreements.
Let me see if I have the mechanics of this right. Let's say an extremist group wants to hijack a deep-sea oil rig in international waters.
Okay.
That specific act is covered by that 1988 Rome Protocol. Because the Philippines signed that protocol decades ago, this 2012 financial law automatically incorporates it.
Yep.
So if someone in Manila raises funds to buy the grappling hooks and the dinghies for that oil rig hijacking, they are guilty of terrorism financing under RA Leong 168.
Without the Philippine legislature ever having to pass a specific law about oil rig grappling hook.
That is mind-blowing.
Exactly. It creates a dynamic, self-updating legal framework. If the international community signs a new treaty tomorrow regarding, say, orbital satellite sabotage,
Oh, wow. Yeah.
and the Philippines ratifies it, the net automatically expands to cover the financing of satellite sabotage. The local law is permanently synchronized with hyper-specific global threats.
Okay, so the state has built this incredibly wide, self-updating net. Now we reach the core of the deep dive, the actual anatomy of the crime.
This is where the hammer falls.
Yeah. Section 4 outlines the core offense, and here's where it gets really interesting. The text says that any person who willfully possesses, provides, collects, or uses property with the intention that it be used, or with the knowledge that it is to be used to carry out a terrorist act, is guilty.
And the penalties are maximal, reclusion temporal to reclusion perpetual.
Basically, decades in prison up to a life sentence, plus massive fines.
The severity of the punishment reflects that Section 2 philosophy. This is treated as a crime against humanity.
But tucked away at the very end of Section 4 is a single sentence that completely subverts how most of us understand criminal justice.
It really does.
It says, and I'm quoting directly here, "For an act to constitute a crime under this act, it shall not be necessary that the funds were actually used to carry out a crime or terrorist act."
This is the paradox of unused funds. It is the concept of preemptive criminality.
It bends the mind. You can be sentenced to life in prison for financing a terrorist act that never actually happened.
Yes.
The bomb never goes off, the plane is never hijacked, the money literally just sits in a bank account.
In traditional criminal law, we punish the outcome, or at least the physical attempt.
Right, like an attempted robbery.
Exactly. Someone is assaulted, a vault is drilled into, a trigger is pulled. There is tangible physical evidence of the crime in motion.
But in the realm of terrorism financing,
The state cannot afford to wait for the physical outcome. The crime is considered fully complete the absolute microsecond the money is collected or provided, so long as the intent to fund terrorism exists in the mind of the financier.
but that raises a terrifying logistical question. If the money just sits there and no violence ever occurs, how on earth does a prosecutor prove what was inside someone's head?
That's the billion-dollar question.
Right. Direct evidence is easy. Direct evidence is an intercepted email that says, "Here is $10,000. Please use it to buy explosives for the attack on Tuesday."
But terrorists aren't usually that stupid.
Exactly. So the law states that knowledge or intent may be, quote, inferred from the attendant circumstances.
Attendant circumstances. Let's spend some time on this because this phrase is the invisible tripwire that everyday people could theoretically stumble over.
Yeah, let's unpack that.
It means looking at the shadows surrounding the transaction. It means looking at patterns of behavior.
Let's play this out with a hypothetical scenario to really understand the mechanics. Let's say we have a listener. Let's call him David.
Okay, David.
David is a well-meaning guy. He runs a small, completely legal, non-governmental organization, an NGO, that provides medical relief to war zones. It's a noble cause.
Okay, so David is trying to get money to an active conflict zone to buy bandages and antibiotics.
Right, but the banking infrastructure in this conflict zone is destroyed. Traditional wire transfers don't work. So David has to get creative.
Makes sense.
He starts using an encrypted messaging app to communicate with his contacts on the ground. He starts breaking up his bank withdrawals into smaller increments, say $9,000 at a time, because he knows the bank requires a bunch of tedious paperwork for transactions over $10,000, and he needs to move fast to save lives.
He's just trying to be efficient.
Exactly. And finally, he uses a decentralized cryptocurrency to actually send the funds to an anonymous wallet address provided by his local contact.
Okay, now let's pause and look at David's actions through the lens of traditional law versus this specific Terrorism Financing Act.
Okay.
Is it illegal to use an encrypted messaging app? No. Millions of people use them for privacy.
Right.
Is it illegal to withdraw $9,000 from your own bank account? No, it's your money. Is it illegal to use cryptocurrency? In most jurisdictions, no.
So every single action David took is, in isolation, completely legal.
But under RA 2168, the state isn't looking at the actions in isolation. They're looking at the attendant circumstances.
The pattern.
Yes. An algorithm at David's bank flags the repeated $9,000 withdrawals. This is a classic pattern called structuring.
Oh, right.
Yeah, it's often used by money launderers to avoid reporting thresholds. So the Financial Intelligence Unit looks closer. They see the destination as an IP address in a known terrorist hotbed.
Because it's a conflict zone.
Right. They see the use of crypto to obfuscate the final recipient. They see the encrypted comms.
And suddenly, David's entirely innocent humanitarian effort looks exactly like the operational profile of a terrorism financier.
Precisely. The state can look at that web of behavior and legally infer the intent to finance terrorism.
Wow.
They could freeze David's accounts, seize his assets, and charge him under Section 4, even if he genuinely thought he was buying antibiotics, and even if not a single act of violence ever occurred.
That puts an immense, almost unbearable burden on the average citizen to constantly police their own financial footprint, doesn't it?
It really does.
If your totally innocent behavior perfectly mimics the attendant circumstances of a crime, you are walking through a legal minefield blindfolded.
And the state accepts that friction. The calculus of this law is brutal but clear. The state would rather risk destroying the financial life of an innocent NGO worker like David and sort it out later in court than ignore a suspicious pattern that results in a catastrophic attack.
They have moved the threshold for the crime all the way upstream.
All the way to the source.
Okay, so let's move past the primary suspect. Let's say the state accurately identifies a malicious financier. What happens to the people around them? Because money rarely moves through just one set of hands.
No, it moves through a complex ecosystem.
And the law builds a cascading waterfall of liability to capture that entire ecosystem. Sections 5 through 9 construct what we can call a web of complicity.
The analogy I like to use here.
Oh yeah, the analogy I keep coming back to when reading these sections is a radioactive spill.
Right.
Think of the terrorism funding as a leaking barrel of highly toxic radioactive waste. You cannot touch any part of the process without getting contaminated. Section 5 states that if 2 or more people simply conspire or agree to finance terrorism, they get the exact same maximum penalty as the person who actually did it.
The agreement itself is radioactive.
Exactly. Then you have the accomplices under Section 6. These are the people who cooperate in the execution of the crime by previous or simultaneous acts.
They didn't initiate it, but they helped carry the barrel.
Right. They get a penalty 1 degree lower. And then Section 7, the accessories. This is where the net gets incredibly wide.
How so?
Well, an accessory is someone who had no part in the actual funding. They didn't know about the attack beforehand, but after the fact, they learn about it and they try to throw a tarp over the radioactive spill.
I see.
They conceal the crime, they destroy the ledger, or they help the financier escape. They get a penalty 2 degrees lower, but they are still looking at severe prison time.
It's a comprehensive dragnet.
Yeah.
But there's a specific provision in Section 9 that radically alters the landscape, not just for criminals, but for entirely legitimate businesses.
Oh, Section 9.
Yeah, Section 9 deals with corporate bodies or juridical persons.
If you are listening to this on your commute and you work in fintech, if you are a compliance officer at a bank, or even if you run a small business that processes international payments, This is the legal tripwire you are walking over every single day.
Because Section 9 states that if a corporation is found to be involved in the offense, the penalty doesn't just fall on the corporation as an abstract entity.
Ugh, fine.
Right, not just a fine. It falls upon the responsible officers who allowed it to happen by their gross negligence.
Gross negligence. That phrase is a nightmare for corporate compliance.
Absolute nightmare.
Let's break down the mechanics of how a bank manager actually goes to jail under this law. Let's say a massive multinational bank is processing millions of transactions an hour. A known terrorist front company uses a slightly misspelled name to open an account, and over 6 months, they funnel $1 million through this bank to a militia.
Okay, so the bank manager didn't actively want to fund terrorism. They didn't wake up and say, let's help a militia today.
Right. But the state investigators come in and they look at the bank's internal systems. They find that the bank's anti-money laundering software, their AML software, was desperately out of date.
Oh, it's bad.
Yeah. They find that the compliance team was understaffed and that 3 different junior analysts had flagged those transactions as suspicious, but the senior manager ignored the alerts because investigating them would slow down business and hurt their quarterly metrics.
That is the textbook definition of gross negligence under this act. The manager ignored the Geiger counter, screaming that there was radioactive waste in their vault.
And because of that negligence, under Section 9, that senior manager is facing actual prison time. And the corporation itself can have its license suspended or completely revoked.
It can face corporate death.
Corporate death. What the state is doing here is highly strategic.
Oh, definitely. The government knows it does not have the manpower to monitor every single SWIFT transfer, every crypto exchange, and every wire service on Earth.
It's impossible.
So they use Section 9 to forcefully draft the entire private financial sector into the national security apparatus. They outsource the surveillance.
Wow.
The state tells the banks, you are now our involuntary watchdogs. Monitor your own systems perfectly, or you will share a jail cell with the terrorists you accidentally enabled.
But to enforce this kind of terror on the banking sector, the state needs to be able to actually see into the vaults.
Right.
All these severe penalties are completely useless if the state can't actually track the money. And historically, the Philippines has an incredibly strict, ironclad culture of bank secrecy, decades of laws protecting the financial privacy of the citizen.
Which brings us to Sections 10 and 11, the powers of the Anti-Money Laundering Council, the AMLC, and the Anti-Terrorism Council.
Yeah, these sections are intense.
To make this terrorism financing law work, they had to effectively bulldoze those historic privacy protections overnight.
Section 10 is the bombshell. It authorizes the AMLC to investigate any property or funds related to terrorism financing. But it explicitly states that the AMLC can inquire into or examine deposits with any banking institution. Wait for it. Without a court order.
Let the weight of that sink in. Without a court order.
The text specifically lists the 3 massive pillars of Philippine financial privacy: the law on secrecy of bank deposits, the Foreign Currency Deposit Act, and the General Banking Law. Section 10 essentially says, if we suspect you of terrorism financing, none of those laws apply to you anymore.
It creates a legal carve-out that states financial privacy is a conditional right, not an absolute one. And the condition for revoking it is simply probable cause established by the AMLC.
So you don't get a heads up.
No. You do not get to stand before a neutral judge and argue your case.
But the power to look at your money is only step 1. Step 2 is taking it away. And this is where we get to Section 11, which grants the AMLC the authority to issue an ex parte freeze order.
Ex parte is a critical legal mechanism here.
What does that mean exactly?
It means from one party. In practical terms, it means the government goes to a closed-door meeting, presents their evidence that your financial footprint looks suspicious, and issues an order to freeze your assets entirely without ever notifying you or giving you a chance to defend yourself.
Again, going back to my opening scenario, you find out your money is gone when your debit card declines at the coffee shop. I have to push back here.
Sure.
Doesn't this completely obliterate the concept of due process? How is it legal to take someone's property without giving them a chance to explain themselves first?
If we connect this to the bigger picture of the digital age, you realize why the law demands an ex parte mechanism. Due process was designed for the physical world.
Oh, how so?
Well, if I want to seize your physical house, I can send you a letter. We can go to court for 6 months. We can argue. Because during those 6 months, you cannot physically pick up your house and mail it to a non-extradition treaty country. The house stays put.
Right. But capital doesn't stay put.
Exactly. If the AMLC sends as a suspected terrorist a polite subpoena saying, "Dear sir, We suspect you of financing an attack. Please come to court next Tuesday so we can discuss freezing your accounts.
What is the absolute first thing that suspect will do? They will open their laptop, log into their accounts, and wire everything to a dark web crypto mixer or an offshore shell company.
Yep.
The money will evaporate at the speed of fiber optic light before the mail carrier even finishes their route.
Capital flight in the modern era is instantaneous. Therefore, the state's intervention must be instantaneous and invisible.
I see.
The element of surprise is literally the only mechanism that makes a freeze order physically possible. If you remove the surprise, the law becomes a toothless suggestion. Section 11 says this initial ex parte freeze is effective for 20 days.
And during those 20 days, your financial life is in a medically induced coma. But let's look at the strategic side of this, because the law isn't just a blunt instrument. It actually has some incredibly sophisticated tactical loopholes built into it.
Section 12 is a perfect example of this. It gives the AMLC the power to defer the issuance of a freeze order for investigative or prosecutorial purposes.
The analogy I use for Section 12 is a mousetrap in your kitchen.
Oh, I like this one.
You see a mouse take a piece of cheese, you hold the trap in your hand, you have the absolute power to drop it and kill the mouse right then and there. But if you hold off, if you just watch the mouse scurry along the baseboards, it might lead you straight back to the nest hidden behind the wall.
In law enforcement, we call this a controlled delivery. You identify a small sum of money moving from a suspected financier to an operative. You could freeze it immediately.
But then you only get the small fry.
Exactly. If you do, you only catch the low-level guy. You burn the operation for a minor victory. Instead, under Section 12, the AMLC can choose to just watch.
They just let it ride.
They trace the wire, they see it bounce to a correspondent bank in Singapore, then to a front company in Dubai, then to a regional commander of the terrorist group. By delaying the freeze, they map the entire hidden architecture of the network.
It's brilliant. But let's say they finally trace the network, they drop the trap, and they execute the ex parte freeze order. The suspect is completely locked out of their life.
Completely locked out.
This brings us back to that massive tension we discussed in Section 2, the promise to protect human rights. How do you reconcile a 20-day secret financial blackout with human rights?
The drafters anticipated this exact constitutional crisis, which is why they built in the humanitarian exemptions under Sections 13 and 14.
Section 13 states that even if a person's funds are completely frozen, they can petition the court or the AMLC to withdraw sums reasonably needed for monthly family needs and sustenance, including medical needs.
The state is legally acknowledging that even a person heavily suspected of planning mass murder still has a fundamental human right to not starve to death and a right to ensure their children have shelter and medicine.
It prevents the freeze order from becoming an extrajudicial death sentence by poverty.
Right.
And crucially, Section 13 also allows withdrawals to pay for the services of counsel. You can use your frozen money to hire a lawyer to fight the state.
But what if you don't have enough money? Or what if the court denies the withdrawal? The state still has to guarantee your right to a fair trial.
So what happens then?
That is where Section 14 steps in. It explicitly exempts the public attorney's office, the PAO, from any liability for providing free legal assistance to the accused.
I found Section 14 fascinating. Without it, the public defenders would be terrified to take the case. We just spent 10 minutes talking about the radioactive spill of complicity.
Exactly.
If a PAO lawyer provides legal services to a designated terrorist, aren't they technically dealing with a terrorist? Couldn't an overzealous prosecutor charge the defense attorney as an accessory?
Absolutely. Section 14 is a necessary legal shield. It says the radiation does not affect the public defender, and the state isn't providing these exceptions out of the goodness of its heart. No, they are doing it to protect the integrity of their own convictions.
Oh, right, because if the state starves the suspect, denies them medicine, and threatens any lawyer who tries to help them with prison time, any subsequent conviction would be immediately thrown out by an appellate court or an international human rights tribunal.
The trial would be declared a farce. Sections 13 and 14 are the pressure valves that keep the entire justice system from exploding into a totalitarian police state. They allow the state to aggressively pursue the capital while maintaining the structural validity of the constitutional process.
It is a remarkable balancing act. Okay, so we have mapped out the entire domestic ecosystem. We understand the crime, the complicity, the bypassed bank secrecy, the strategic delays, and the human rights exceptions.
We covered a lot of ground.
We did. And all of this makes perfect, terrifying sense if the suspect is sitting in an apartment in Manila or Cebu using a local bank. But we live in a globalized world. terrorism is rarely a purely local affair anymore. What happens if the perpetrator is sitting on a different continent entirely?
This is where the law flexes its true muscle. Section 19 deals with the extraterritorial application of the act. It takes this domestic Philippine law and stretches its jurisdiction far beyond the physical borders of the country.
Now, as a general rule, laws usually stop at the border. If I'm driving on a highway in France and I go over the speed limit, a police officer in the Philippines doesn't issue me a ticket. Jurisdiction is territorial.
Normally, yes.
But Section 19 outlines 5 specific scenarios where RA 10168 applies physically outside the Philippines. Let's dig into the mechanics of this.
The first scenario is simple. If someone commits the crime inside the Philippines, even if they are a foreigner.
Okay, that's standard.
The second scenario applies if the crime occurs on a Philippine ship or airship.
Which is standard international maritime and aviation law. A flag vessel is considered a floating piece of sovereign territory.
Exactly. The third scenario applies to crimes committed within a Philippine embassy or consulate abroad. Again, standard diplomatic sovereignty.
Yeah.
But the fourth and fifth scenarios are where the net expands aggressively. The fourth scenario states the law applies if the crime is committed against Philippine citizens or persons of Philippine descent, where their citizenship or ethnicity was a factor in the crime.
Wait, this is targeting global hate crimes and specifically targeted terrorism?
Yes, it is.
So let's imagine a highly complex logistical nightmare. A financier who is a German citizen sitting in a coffee shop in Berlin uses a decentralized cryptocurrency to fund a local militia group in the Middle East. And the specific stated goal of that militia is to attack a compound of overseas Filipino contract workers.
Under Section 19, the Philippine government claims full legal jurisdiction over that German citizen sitting in Berlin.
That is staggering. A non-citizen in a non-Philippine territory using a borderless currency to fund violence in a third country. But because the target of the violence was Filipino, the domestic law applies.
It's a huge claim of jurisdiction.
And the fifth scenario says the law applies if the crime is committed directly against the Philippine government, no matter where it happens. Plus, it covers any Filipino national who commits these crimes anywhere on Earth.
This is the legal manifestation of our new reality. The digital financial age has completely obliterated the traditional concept of territory. A border is just a line on a map, but capital flows globally in milliseconds. Because the threat is borderless, the laws designed to suppress its financing must also attempt to be borderless.
But declaring jurisdiction on paper is one thing. Actually enforcing it is a massive geopolitical headache. You have this German financier in Berlin. The Philippines has a warrant for his arrest based on RA 1168. The Philippine police can't just kick down the door of a cafe in Berlin.
No, they certainly cannot.
So how do they actually get him?
That is precisely what Section 20 addresses, extradition. It allows the Philippines to use those international treaties we discussed at the very beginning.
Like the International Convention for the Suppression of the Financing of Terrorism?
Exactly. They use those as the legal basis to formally request the extradition of the offender from Germany.
So the local law points back to the international treaty to demand the suspect.
Yes, but what if Germany refuses? What if they say, we don't recognize your extraterritorial claim?
Which is very possible.
Very possible. Section 19 actually has a fallback mechanism. It mandates that if extradition is impossible, the Philippines shall submit the case to their own Department of Justice for prosecution in the same manner as if the act had been committed in the Philippines.
They will try you in absentia. They will hold the trial, present the evidence, and convict you without you even being in the room.
And once that conviction is logged, the trap is permanently set. You might be safe in Berlin today, but the moment you take a vacation, the moment you step off a plane in a country that does have a favorable extradition treaty with the Philippines, or an Interpol red notice is flagged at passport control.
The track springs shut.
Exactly. You are detained and shipped to Manila to serve your sentence for a financial crime you committed on a laptop 5 years ago and 3,000 miles away.
It creates a legal dragnet that slowly, inevitably spans the entire globe. It proves that this local law is genuinely a gear in that massive international machine we talked about in the opening.
It is the architecture of an invisible global war.
It is truly staggering to step back and look at the whole picture. We started this deep dive by moving away from the physical battlefield, the drones and the trenches, and stepping into the bank account.
It's a completely different perspective.
We have traced an incredible journey. We saw how a single line of digital code, an intangible asset, can be classified as the property of terrorism. We map the radioactive spill of liability, seeing exactly how a corporate compliance officer could face actual prison time for the gross negligence of ignoring an algorithm's warning.
And we explored the brutal necessity of bypassing bank secrecy, understanding why ex parte freeze orders are the only effective weapon against instantaneous capital flight.
Because money moves too fast.
Too fast. And we examined the delicate constitutional balancing act of providing humanitarian exemptions to prevent the state from becoming a monster in its pursuit of monsters.
And finally, we saw how the traditional borders of a nation have been redefined, allowing a domestic law to reach across the planet to punish the intent to finance violence. It makes you realize that every single time you interact with the financial system, every time you tap your card, wire money to a relative, read the terms of service on a new crypto wallet, or see a headline about global sanctions, you aren't just engaging in economics.
No, you're not.
You are interacting with this invisible, hyper-vigilant architecture. You are moving within the grid created by laws exactly like RA 168. The front line isn't a desert halfway across the world. The front line is everywhere money flows.
And as we conclude our analysis of this source text, this entire legal structure raises a deeply important question. A final thought to ponder as technology accelerates. Well, we spent a lot of time discussing Section 4, where the crime is legally complete even if the funds are never used, and where the intent to finance terrorism can be inferred entirely from circumstantial evidence and patterns of behavior.
The preemptive criminality, the hypothetical of David, the NGO worker.
Exactly. Right now, inferring that intent requires human investigators. It requires financial intelligence units reviewing reports. But as we move deeper into an era completely dominated by artificial intelligence, where machine learning algorithms are ingesting and monitoring our digital financial footprints 24 hours a day, searching endlessly for those exact attendant circumstances.
Oh, man.
How close are we to a paradigm shift? How close are we to a future where citizens are routinely flagged, investigated, and their entire financial existence frozen for financial thought crimes, long before any physical action is ever taken, simply because a black box AI decided their legitimate transaction history mimicked the pattern of a threat?
That's terrifying.
If the law legally allows intent to be inferred from patterns, and AI becomes the ultimate infallible pattern recognition tool, where exactly is the line between preventative national security and preemptive punishment?
That is a chilling and absolutely necessary question to leave off on. The invisible architecture we've explored today is only going to get smarter, faster, and more autonomous. The net is only going to get tighter. Thank you for joining us on this deep dive into the hidden rules that govern the flow of capital and global security. We leave you to chew on that intersection of your own wallet, the global financial dragnet, and the future of your privacy. Because as we've seen today, the battlefield isn't out there in the distance. It's right there in your pocket.
Welcome to the debate. If you've ever looked into how medical researchers try to eradicate aggressive tumors, you might be familiar with a strategy called angiogenesis inhibition.
Right, choking off the blood supply.
Exactly. Rather than just attacking the cancer cells directly, these treatments target the actual blood vessels that supply the tumor. I mean, if you cut off the nutrient supply, the tumor starves and the disease simply stops spreading.
It's a brilliant strategy in theory, but, the human body is a complex, highly interconnected system. If you deploy a chemical agent that aggressively shuts down blood vessels, you run the very real risk of starving healthy tissue too.
Yeah, it's a delicate balance.
Right. You risk damaging vital organs and creating systemic hypoxia. If the treatment isn't perfectly calibrated, it essentially becomes indistinguishable from the disease itself.
And that delicate high-stakes calibration is exactly what brings us to the table today. We are looking at a piece of legislation that, it tries to perform this exact medical procedure on the financial network of global terrorism.
But critics argue it might kill the patient in the process.
Exactly. We are examining the Terrorism Financing Prevention and Suppression Act of 2012 from the Philippines, specifically Republic Act number 10168. The real friction here is that core trade-off. My position is that this law is a highly targeted, absolutely necessary legal instrument. It utilizes precise, time-bound mechanisms to dismantle the financial infrastructure of terrorism long before an attack can ever occur.
And my position is that while the objective of stopping terrorism is, undeniable, the mechanisms the state uses to achieve it grants dangerously broad administrative powers. When you allow an administrative council to bypass strict banking privacy laws and freeze a citizen's assets without any initial judicial oversight, you're creating a structural risk to fundamental due process.
Let's start by looking at what this law actually criminalizes, specifically in sections 2 and 4, because it represents a massive paradigm shift in how the state approaches law enforcement. For decades, the justice system has been largely reactive. A crime happens, you investigate, you punish.
Right, the traditional model.
Right, but this legislation, driven by strict mandates from the UN Security Council, Chapter 7 of the UN Charter specifically, compels the state to act preventatively. We aren't just criminalizing a bombing anymore. We are criminalizing the financial supply chain.
Which means targeting the act of providing or collecting funds.
Yes, the intent. And the most crucial detail here in Section 4 is that for an act to constitute a crime, the state does not have to prove that the funds were actually used to carry out a terrorist act.
Wait, so just the collection itself?
Exactly. If you willfully provide or collect property with the intention or knowledge that it will facilitate terrorism, you've committed the crime. We are stopping the bomb from being built rather than just, punishing the person who detonated it. And to show how serious this is, the state backs it up with severe penalties. We're talking reclusion temporal to reclusion perpetua, basically 12 years to life in prison, along with heavy fines from 500,000 to 1 million pesos.
I don't think anyone argues with the logic of stopping the bomb before it's built. I mean, the goal of starving terrorism of capital is entirely valid. But defining a crime on paper is one thing. The actual procedural tools the government uses to enforce it, that's another entirely.
You're looking at the enforcement mechanisms.
Yes. My profound concern isn't the definition of the crime. It's how the state investigates and halts suspected funds without the traditional checks and balances we rely on. We need to look at sections 10 and 11.
Ah, the powers granted to the Anti-Money Laundering Council, the AMLC.
Precisely. In our legal tradition, if the government wants to take your property or lock down your money, it requires due process. Usually that means notice and a hearing before a judge. But under Section 11 of this law, the AMLC can issue an ex parte freeze order.
Right, an immediate halt.
But for those unfamiliar, ex parte means the government goes to the authority entirely alone. The accused has no voice, no warning, and no opportunity to defend themselves before the deprivation of their property happens. And property here doesn't just mean a single checking account. It applies to property of every kind. You just wake up one morning and your entire financial existence is paralyzed.
I see why you think that, but let me give you a different perspective on the mechanics of modern finance. Think of the ex parte freeze order not as a final judgment, but as a financial tourniquet.
A tourniquet?
Yes, we are dealing with digital money, wire transfers, cryptocurrency, layered transactions through shell companies. These move across international borders in milliseconds. If the government is required to serve a polite notice to a suspected terror financier and wait for a court hearing next Tuesday, those funds will be gone before the judge even walks into the courtroom. The surprise element isn't a bug in the system, it is the only thing that makes the freeze effective.
But the cost of that surprise is a severe suspension of due process. Imagine a legitimate humanitarian charity operating in Mindanao. They run clinics, they distribute food. Suddenly, based on an unverified tip or just a flawed internal assessment by this administrative council, their accounts are completely zeroed out.
Well, they aren't seized permanently.
But there is no warning, they can't buy medical supplies, they can't pay their local staff, their reputation is instantly destroyed, and all of this happens without a judge ever looking at the evidence to determine if there's actual probable cause.
But that suspension of due process is strictly temporary, which is a crucial distinction. The law recognizes the severity of an immediate freeze, which is why it implements a strict structural check. The AMLC's unilateral freeze is capped at 20 days. It's just a holding action.
20 days is a long time when you can't buy food.
True, but if the state wants to extend that freeze up to 6 months, they can't just decree it themselves. They must file a petition with the Court of Appeals, so the judiciary does step in to evaluate the evidence, strictly limiting the administrative action.
I'm sorry, but I just don't buy that. Let me tell you why. That 20-day limit is very small comfort to the charity I just mentioned. 20 days of frozen accounts in the real world means missed payrolls, defaulted loans, and ruined lives. And that supposed comfort vanishes completely when we back up a step and look at how the AMLC decides to deploy this tourniquet in the first place.
Because you have to find the assets before you can freeze them.
Exactly. Since assets cannot be frozen unless they are first found, we naturally have to shift to the investigative powers. And this is where the erosion of rights gets even steeper. Under Section 10, to find this money, the law authorizes the AMLC to inquire into and examine private bank deposits entirely without a court order.
Only under specific conditions.
But it completely overrides 3 major privacy laws: Republic Act 1405, the Foreign Currency Deposit Act, the General Banking Law. It allows an administrative body to conduct phishing expeditions into private bank accounts based solely on its own initiative or just a request from the Anti-Terrorism Council.
I think we need to address the elephant in the room here. If you're listening to this, you might be thinking, well, if you aren't funding terrorists, you have nothing to hide. Let them look at the bank accounts.
Right. That's the classic defense of surveillance. But the danger is that we are removing the neutral referee. We have judges for a reason to look at a request for a warrant and determine if the state actually has probable cause, or if they are just harassing a political opponent or a marginalized group. When you let an executive agency bypass the judge, the boundaries of who gets investigated tend to expand very quickly.
That's an interesting point, though. I would frame it differently. Financial privacy is a cornerstone of a stable banking system. Yes, but it cannot be an impenetrable shield when we are tracking international terrorism. Terrorism financing rarely looks like a direct wire transfer with "for the bomb" written in the memo line.
Obviously not.
It involves incredibly complex methods like smurfing, which is where massive amounts of illicit cash are broken down into hundreds of tiny, inconspicuous deposits to avoid triggering alarms. By the time you get a warrant to look at account A, the investigator realizes the money was moved to account B yesterday.
Which is exactly why we have judges who are capable of reviewing complex warrants rapidly.
But requiring a court order for every single inquiry in a massive, sprawling financial web would paralyze the investigation. You'd have to go back to the judge for a new warrant for every new account you uncover. The investigation would always be 2 steps behind. And it's important to clarify that this exception isn't a blank check. The AMLC can only bypass a warrant when there was probable cause specifically related to the financing of terrorism. They can't use this tool to chase down minor tax evaders.
But again, who defines the probable cause? The AMLC itself. They are acting as both the investigator and the magistrate granting the investigative power. And this brings us to an even broader issue regarding who the state can target. If these investigative powers represent a massive net being cast without judicial oversight, we need to look at how far across the ocean that net actually reaches.
Ah, you're referring to Sections 5 and 19, the conspiracy clauses and the extraterritorial application.
Yes! Let's look at the sheer scope here. Under Section 5, mere conspiracy to commit the crime of financing terrorism, so just 2 or more persons agreeing to commit the offense, carries the exact same severe penalty as the actual commission of the crime. Think about that.
It's preventive.
But 2 people merely coming to an agreement to provide funds face 12 years to life in prison. And when you combine that with Section 19, the extraterritorial provisions, it gets alarming.
How so?
Modern terrorism is inherently stateless. It doesn't respect borders. I agree, but look at what the government is claiming. The state is claiming the right to apply these domestic criminal laws to individuals who are physically outside the territorial limits of the Philippines, like in embassies, on ships, or just acting against Philippine citizens from abroad. If 2 foreign nationals sitting in a cafe in Europe agree to send money to a flagged organization, the state claims criminal jurisdiction over them. We are essentially risking massive international jurisdictional overreach based on mere agreements to fund.
But a domestic-only law against terror financing is, well, it's like building a fence that only goes halfway around your house. It just doesn't work. The extraterritoriality in Section 19 is a vital evolution. It ensures that foreign nationals plotting against the government or against its citizens from safe havens abroad cannot use their geographical location as a legal loophole.
It certainly sounds like the state acting as a global financial police force, though.
It isn't, because the law explicitly states that this global reach is subject to existing international treaties, specifically the International Convention for the Suppression of Terrorism. There's a core principle in international law called aut dedere ad judicare, which basically translates to extradite or prosecute.
Right. Standard treaty language.
Exactly. The UN and international treaties explicitly require member states to establish jurisdiction in exactly these scenarios. We are honoring our international commitments and closing blind spots. It's a measured, internationally coordinated stance, not some rogue overreach.
I understand the treaty obligations, but when you fuse massive international mandates with domestic administrative overreach, the individual human being gets crushed in the gears.
Oh, let's explore that, because I actually don't think the individual is crushed. Let's ground the debate by looking at the fail-safes built into the law for those who are targeted. Specifically, in sections 13 and 14, what actually happens to an accused person whose assets are frozen? The drafters recognize the severity of this action, which is why they included explicit humanitarian exemptions.
You mean the allowance for survival?
Exactly. Section 13 guarantees that a person whose property has been frozen can withdraw sums reasonably needed for monthly family sustenance, medical requirements, and crucially, the services of legal counsel. The state does not intend to starve the accused children or deny them a lawyer.
Wait, let me make sure I'm understanding the scale of this, especially regarding the legal defense part. If I'm an attorney, particularly a public defender, and I use my state-provided budget or I accept funds from a frozen account to defend an accused terrorist, am I personally at risk of having my own assets frozen for, facilitating them?
That is specifically addressed in Section 14. The law explicitly protects the public attorney's office, the PAO, from any liability for using their funds to defend the accused, so they can't be prosecuted as accessories. The guarantee of legal representation is hard-coded into the mechanism.
That's a compelling argument. But have you considered the actual power dynamic this creates for a private citizen trying to clear their name? It is deeply troubling. Yes, Section 13 says you can withdraw money for your family's survival and to hire a private lawyer. But who approves that withdrawal? Depending on the timing of the freeze, you often have to go back to the AMLC itself.
Well, the authority overseeing the freeze manages the exemptions. That is logically consistent. You have to prevent abuse of the exemption.
It might be logically consistent, but it is structurally oppressive. Imagine the scenario again. An administrative body decides unilaterally that you are a terror financier. They freeze every asset you have without warning. To fight this accusation in court, you need to hire an expert lawyer. To pay that lawyer, you have to go back to the very agency that just ruined your life and essentially ask them for an allowance.
It's an oversight measure.
But the state completely controls the purse strings of the accused's defense and their daily bread. How can anyone mount a vigorous independent defense against a well-resourced government when that same government is dictating exactly how much they are allowed to spend on their own lawyer? It heavily prejudices the defense right out of the gate.
I see the tension there, I really do, but look at the alternative. If a suspected terrorist could access their frozen funds freely just by claiming it was for legal fees, what is to stop a sophisticated network from liquidating a massive account by routing it through a corrupt law firm with exorbitant retainer agreements? The oversight of the withdrawal is absolutely necessary to ensure the humanitarian exception doesn't become a massive loophole for capital flight.
But giving that oversight to the investigators?
And remember, if the agency arbitrarily denies a reasonable request for medical funds or legal fees, the aggrieved party always has access to the courts to compel that release. The fail-safes are layered.
Well, I respect that public defenders are shielded under Section 14. Forcing an individual into a situation where the state dictates their access to their own private wealth that hasn't been proven illicit in a court of law yet, remains a severe distortion of a fair trial mechanism. By allowing financial investigators to determine what is reasonably needed for a family's survival, we are basically giving accountants the power of a family court judge.
As we draw this examination to a close, I think it's essential to synthesize where we actually stand on this trade-off. My perspective remains that Republic Act 10168 represents a harsh but absolute necessity of modern security. The architecture of terrorism has evolved into a sophisticated, borderless financial network that moves at the speed of light. To dismantle it, the state requires tools that are equally rapid and far-reaching.
Right.
The severe penalties for conspiracy, the extraterritorial reach mandated by UN treaties, and swift administrative tools like the 20-day ex-parte freeze are precisely what is required. We simply cannot fight digital age terrorism with analog-era warrants. And crucially, the law limits administrative overreach by mandating that appellate courts must step in for any long-term freeze, ensuring the urgency of security is ultimately balanced by the scales of justice.
My conclusion remains that while the objective of starving terrorism of its capital is an indisputable good, the mechanisms utilized here set deeply dangerous precedents. When you strip away decades of established bank privacy laws without requiring judicial warrants, and you allow an administrative body to unilaterally freeze assets based on its own internal logic, you fundamentally erode due process.
Even with the 20-day limit?
Yes, because furthermore, giving that same administrative body the power to dictate the living and legal allowances of the accused creates an imbalanced power dynamic that threatens the core of a fair defense. Security is paramount, yes, but a security apparatus that operates without immediate, strict judicial checks risks damaging the very democratic freedoms it claims to be protecting.
We clearly have a fundamental disagreement on whether the administrative powers granted to the AMLC are too broad. However, I think we easily converge on the reality that tracking modern financial crimes requires an entirely different playbook than what traditional, reactive criminal law provides. The era of waiting for the crime to happen before acting is truly over.
Oh, absolutely. We definitely agree that the financial landscape has fundamentally shifted, and the speed of digital transactions requires a modernized legal framework. The question isn't whether we should stop terror financing, but how much collateral damage to our civil liberties we are willing to accept to do it.
And there is certainly much more to explore within this material, particularly the intricate interplay between domestic enforcement and international treaty obligations.
Ultimately, this law forces us to decide which risk we are more willing to live with.
The risk that a terrorist organization moves its money slightly faster than a judge can issue a warrant, or the risk that the state can financially paralyze any citizen on a suspicion without ever stepping foot in a courtroom.
It's a massive trade-off, and one we leave you to consider. Thank you for joining us on The Debate.